The Wall Street Journal, a major publication known for its diverse readership cutting across political lines, recently dropped a bombshell opinion piece that's causing waves far beyond just sports circles. The piece raises serious questions about whether the WNBA is violating CaitlinClark's civil rights, and it suggests that the legal fallout from this situation could completely upend the league as we know it. This is no longer just about basketball. It's about potential federal investigations, congressional hearings, and lawsuits that could change the entire landscape of women's professional sports. The article argues that the WNBA may have created a hostile work environment for Clark, a claim that carries serious legal weight. Sean McLean, the author, didn't hold back in his assessment, essentially accusing the league's leadership of ignoring a systematic pattern of targeting Clark, which may constitute federal civil rights violations. The Wall Street Journal isn't some niche sports blog. It's a heavyweight business publication whose entry into this debate signals that the issue has escalated beyond typical sports disputes into serious legal territory. They point out that CaitlinClark, much like Michael Jordan did for the NBA, has transformed the WNBA's fortunes. Viewership is up by 366%, app engagement has soared by 613%, and merchandise sales have increased by 601%. These aren't minor bumps, but massive shifts that have literally saved the league from irrelevance. However, instead of protecting Clark, the league appears to be treating her like a problem, ignoring the relentless physical targeting she endures on the court. The article suggests that WNBA officials like Commissioner Kathy Angelberg and NBA Commissioner Adam Silver should be compelled to answer uncomfortable questions about why the league fails to protect its biggest asset. Fans and players alike have noticed this problem. Some fans have even gone as far as to accuse opponents of assaulting Clark during games, describing it as battery. The statistical evidence is stark. Clark absorbs 17% of all flagrant fouls in the league, double the rate of her peers, a pattern that cannot be chalked up to mere coincidence or bad luck. This kind of data is precisely what civil rights lawyers look for when building discrimination cases. Inside the league, voices like Sophie Cunningham of the Phoenix Mercury have spoken out, stating clearly that the star player isn't being protected. This isn't just fan speculation. It's a professional athlete calling out the league's failures. Clark herself has commented on the unfairness, noting that everyone is physical with her and that officials often let fouls against her go uncalled, highlighting a glaring double standard. Injuries further complicate the picture. Clark has missed over 10 games plus the All-Star game due to injuries sustained on the court, and when she's out, the All-Star ratings drop by 55%. Showing how critical she is to the league's success. These injuries aren't just bad luck. Many result from plays that wouldn't be tolerated if they happened to other players, raising questions of negligence on the part of the league. Beyond physical treatment, the issue takes on additional dimensions with allegations of racial bias. Asia Wilson, a fellow player, suggested race plays a major role in how Clark is targeted and treated, opening the door to legal claims under civil rights law. Importantly, such laws don't require explicit intent to discriminate. If a pattern of disparate treatment motivated by race is present, federal agencies can investigate and enforce corrective measures. The article references key legal precedents like Harris versus Forklift Systems from 1993, which established the definition of hostile work environments, and Texas Department of Community Affairs versus Burdine from 1981. Which addressed disparate treatment under Title VII of the Civil Rights Act. These cases provide a legal roadmap for how Clark could successfully challenge the WNBA's conduct. Moving further into the league's internal dynamics, the piece notes that team owner Sheila Johnson publicly questioned Clark's worthiness for honors like Time's Athlete of the Year. Such statements, legally speaking, could be used to demonstrate hostility towards Clark within league leadership. Coupled with Clark's controversial omission from the Olympic roster, despite her popularity and talent, a pattern of exclusion or retaliation emerges that strengthens the discrimination claim. Politically, the stakes are escalating. Senator Jim Banks has already sent a letter to Commissioner Angel Berg demanding explanations for Clark's treatment, signaling that this isn't just a sports matter but a political one. Congressional involvement could lead to hearings that force WNBA leaders to answer for their actions in a very public way. Imagining Angel Berg and Silver having to testify before Congress about why their star player is effectively being treated like a punching bag is dramatic and potentially damaging publicity. Another layer of seriousness comes from the suggestion that the U.S. Department of Labor might investigate workplace safety in the WNBA. This federal jurisdiction means if the league is found failing to provide a safe working environment for Clark, real legal consequences could follow, far beyond mere bad press. Even more consequential would be the involvement of the Department of Justice's Civil Rights Division, which investigates systemic discrimination and has the power to compel structural reforms. When these federal agencies start scrutinizing your league, it's a major red flag. The article also introduces the so-called nuclear option, antitrust and broadcast law threats. Professional sports leagues operate with special legal exemptions that allow them to function effectively as monopolies. If Congress were to reconsider these exemptions because of how the WNBA treats Clark, it could completely disrupt the league's business model and operations. The timing of all this is fascinating because it coincides with observable differences in how games are officiated depending on whether Clark is playing. The Indiana Fever's recent winning streak without her has been marked by noticeably less physicality on the court, providing a sort of natural experiment that highlights just how much extra contact Clark normally faces. This is compelling evidence of selective enforcement, which is a key factor in discrimination cases. The fact that no player has been suspended for flagrant fouls against Clark, despite the documented targeting, shows a disturbing inconsistency in how rules are applied. The Marina Mabre incident, a blindside hit that could have seriously injured Clark but was dismissed as a hard foul, and the DJ Carrington play that nearly ended her career, demonstrate the genuine danger she faces every time she steps on the court. What makes the Wall Street Journal's article so striking is that it's coming from a respected, business-focused publication rather than a sports outlet with an agenda, underscoring the gravity of the issue. The league's own numbers confirm Clark's immense value. Viewership spikes, merchandise sales soar, and fan engagement climbs with her presence. Yet, the league's failure to protect her defies simple business logic, especially considering that direct revenue depends so heavily on her participation. Moreover, the article warns that internal league communications could become critical evidence if federal investigators obtain them. Email discovery often reveals the so-called smoking gun, proving intentional bias. If messages between league officials discussing Clark's treatment exist, they could be devastating in court. The article draws a parallel to Title IX enforcement in college sports, where the federal government has already taken action against over 60 schools for gender discrimination in athletics. If similar steps are taken against the WNBA, it would be a high-profile intervention given the league's professional status. Antitrust threats loom large for league officials because their special legal status shields them from normal business competition laws. Losing that status would expose the WNBA to standard competition rules, forcing it to operate under entirely different conditions. Given the political landscape and Clark's popularity, this could easily become a bipartisan issue with politicians eager to act. Real-time evidence of different officiating standards when Clark isn't playing only strengthens any legal case. This isn't theoretical. It's happening right before our eyes and provides powerful proof of discrimination. The article's conclusion, that this could become a very public and ugly scandal involving federal investigations, congressional hearings, and lawsuits, seems almost understated given the stakes. This controversy could damage the league's reputation and financial viability in a serious way. By framing Clark's story as a civil rights and legal issue, rather than just a sports controversy, the Wall Street Journal has legitimized concerns many fans and analysts have raised for months. This transition from sports debate to serious legal analysis signals that the WNBA should be deeply concerned. Civil rights investigations, political scrutiny, and antitrust threats are existential risks, not mere bad publicity. The league is at a crossroads, and the coming months could redefine women's professional basketball. The Wall Street Journal's involvement has amplified this story far beyond the typical sports conversation, turning it into a major Hollywood buzzing topic. Fans, players, and political figures alike are watching closely. The questions now revolve around how the WNBA will respond and whether CaitlinClark will receive the protection and respect she deserves. The league's future depends on it. What do you think will happen next? Drop your thoughts below.